Hello, I'm Dr. David Shapiro, and we are going to be talking about some recent developments from the Florida Board of Psychology affecting the practice of psychology in this state, as well as some recent input from the American Psychological Association in terms of the new specialty guidelines for forensic psychologists and the child custody guidelines. Let's turn first to the Florida Board of Psychology. There has been an increased emphasis in recent board deliberations dealing with the whole issue of representation of oneself to the public and also even more detailed issues of supervision, adequacy of supervision and documentation of supervision. Let's turn first to Florida statutes, General Florida Statutes 456.072, which prohibits, and I quote, misleading, deceptive, or fraudulent representations related to one's practice. While very few psychologists commit out-and-out fraud, there are a number of practices which are coming under increasing scrutiny. People, for instance, who do not have board certification, but call themselves, quote, board eligible, unquote. As most people know, there is no such thing as board eligibility in psychology. There may be board eligibility in medicine, perhaps in some other fields, but in psychology, it is either board certification or nothing. So board eligibility really means nothing more than the fact that somebody has applied and perhaps gotten the written materials or submitted an application. But it has absolutely no meaning. So this is the kind of thing that the Board of Psychology is taking a close look at these days. There is also the issue of advertising. Again, not outright fraud, but misleading or deceptive representations. In one instance, there was a psychologist who had on his letterhead his name, his doctorate, PhD, and it said diplomate, American Board of Professional Psychology, but did not specify the area in which his diplomate had been granted. It then went on to title the report Neuropsychological Evaluation. Clearly, the implication was that his diplomate, that is, his advanced certification, was in neuropsychology. It was not. It was in industrial organizational psychology. The implication was clear. He was trying to pass himself off as board certified in one area when in fact his board certification was in another area. Another perhaps more blatant example of this that came to the attention of the board was someone who had been distributing business cards which described herself as, after her name, MS, that is Master of Science, which she was, ABD, Consultant in Forensic Psychology. Now, the general public does not know that ABD means all but dissertation. It looks like it's American Board of something, but it is a clear misrepresentation, especially when it is followed by Consultant in Forensic Psychology. In both of these cases, the psychologists involved were ordered by the board to present or promote new letterhead and new business cards. It could have been more serious, but the board in these cases was somewhat lenient. But this is what is meant by misleading and deceptive. It doesn't quite reach the point of fraudulent, though someone might argue that in fact it was fraudulent. Now, another area that the board is taking a very close look at is performing professional responsibilities that one is not competent to perform. Competence, as you know, is defined in the APA Ethics Code as gained by knowledge, experience, that is supervised experience, and training. What happens in this era, especially this era of managed care, when people are not doing well in therapy practice and are seeking other avenues of making money, they take a few courses in a particular area and then declare themselves to be an expert in that area. Clearly, the APA Code of Ethics and the Florida Board of Psychology regulations do not carefully define what competent is or how much training one has to have in order to call oneself competent. However, a good caution to observe is the fact that it should be decided rather conservatively. Do not overrepresent one's qualifications. Do not claim qualifications in an area in which you have had minimal training. An example comes to mind of a psychologist involved in a case where a person had suffered severe sexual abuse, and it turned out that just prior to his involvement in the case, he took one workshop on how to interview victims of sexual abuse. This is clearly not sufficient training or experience to call oneself an expert in that area. And yet this was the way this psychologist presented himself when he went to court, as an expert in sex abuse. It was not until the opposing counsel cross-examined him that it became clear that his training in this area had consisted of one workshop, and that had been done shortly before the his involvement in the particular case. Even more concerning, or more concern these days, is the issue of delegating tasks to or contracting with someone who you know is not qualified by training or experience to perform that task. This clearly means that there is also a need to assess these skills in individuals with whom you contract, that is, who provide services for you, and whom you supervise or are employees of yours. Now, the fact is that a number of psychologists these days have set up what I like to call mega clinics. That is, they run many clinics across a particular state, and they are listed basically in name only as supervisor, not realizing the really heavy responsibility that a supervisor actually has in a particular case. So to have one of these series of clinics where in fact you do not actually supervise an individual closely is really asking for trouble. I'm reminded of one case where a psychologist actually had approximately a dozen clinics all across a particular state. he listed himself as supervisor of the staff in all of these clinics, and yet he provided little, if any, supervision, but did, in fact, sign off on the reports, never having seen the clients, never having sat down and had face-to-face supervision, and certainly not assessed the capabilities of each of these individuals for their performing of the activities. In this particular case, one of the individuals supervised by this psychologist was supposed to be seeing a child and his father in what was described as court-ordered supervision. The psychologist, as I said, provided no face-to-face supervision with the supervisee, who in this case was a professional counselor. And the counselor recommended that the supervised status could be lifted, that the father could have unsupervised visitation with the child. The child later experienced a psychotic episode and had to be hospitalized, and the mother filed suit. Now, of course, the suit goes against the supervising psychologist. And in the process of discovery, they found out that there was absolutely no documentation of any face-to-face supervision whatsoever. This is getting to be a very risky practice in this day and age. Just one other point that is a minor point, but perhaps is illustrated by the example I just gave of the professional counselor who was supervised by the psychologist, allegedly, that any advertisement for healthcare services must identify the type of license, or in fact lack of license, that the person holds. So if this person were in fact a licensed professional counselor, it would have to indicate that, any kind of advertisement, as well as supervised by, and the name of the supervisor would have to be given. In another case that I became aware of, someone who was in fact an unlicensed psychologist and was being supervised by a licensed psychologist, in fact set out to have an independent practice, and basically avoided the situation by not listing licensure on her letterhead. This, in fact, was very successful for her. She managed to get on a list of individuals who did court-appointed cases in family law situations, and it wasn't until an ethics complaint came up that it was discovered that she in fact did not have a license and was managing to get these cases by virtue of the fact that she basically omitted it from her letterhead, and nobody in the court system had actually paid attention to it. Finally, we have to look at the fact that, again, in this era of managed care, with managed care companies restricting the number of sessions that someone can be seen, that some psychologists have resorted to what we call upcoding a particular diagnosis. This occurs very frequently in personal injury cases, but may well apply in general cases of psychotherapy as well. So in these cases, in order to obtain more sessions, Either the diagnosis is changed from the initial diagnosis to one that would merit more sessions of psychotherapy, or the diagnosis is, you might say, use a common term, fudged from the very outset, so that where a person may have an adjustment disorder, it is called post-traumatic stress disorder. Or where they may have a dysthymic disorder, it may be diagnosed as a major depression in order to obtain more sessions from the insurance company or managed care company. While this very rarely comes to the attention of the authorities, were it to come to the attention, say, of a licensing board, they would look carefully at the documentation in the record and compare it to the actual diagnosis made, and see whether the progress notes and assessment and treatment plan in fact match that diagnosis, or whether there seems to be what we call an upcoding. This is, of course, not only unethical, but can be illegal and can get the psychologist charged with insurance fraud. Now, there has been, getting back to the issue of supervision, a tremendous amount of concern on the part of the board about the delegation of professional responsibilities. I covered some of this before about supervisors who do not really supervise, but there is a concerted effort on the part of the Board of Psychology at the present time